RICO. In fact, it's in a book I wrote 8 years ago. It's titled The Erwin Rommel School of Law, How to Defeat an Illegal Legal System, and it's got the whole RICO laid out in it. Maybe it's in the sequel, Son of Erwin Rommel. I don't know. It's been a while since I've read either one of them. But the statute I want you gentlemen to become extremely familiar with. It's Title 28, United States Code, Section 372, subparagraph C, subparagraph 1. I would strongly suggest you write this down because this is the ultimate statute for fighting information. It was enacted by Congress, Title 28, United States Code, Section 372, C1. It's a small c and a small 1, each in parentheses. This particular statute was enacted by Congress in 1981, and up until 1997, and this little problem we had with this federal judge, Rudy M. Brewster, there had never been more than 304 of them filed in the entire United States against all 800 federal judges. And so I was at my wit's end trying to help my friend there in San Diego, and I was at a seminar in Charlotte, North Carolina. I said, you know what? I said, there's only one way I know of to get this jerk's attention. Here's what I'm going to do. I'm going to ask for volunteers, and I'd already done up a 372 petition. If you call the 8th Circuit Court of Appeals, or have your family call them or write to them, tell them you want the book on a complaint for judicial misconduct, and they will send it to you free of charge. Now, in the years between 1981 and 1997, yes, sir. Okay, the complaint for judicial misconduct, yeah, they'll send it to you free. All you have to do is write to them, and they will send it to you free. Study this book well, gentlemen, because this is the key to fighting information. Well, this particular seminar, like I said, I was at my wit's end, so I said, I want everybody here to volunteer. Thank you. And I want you to send in one of these things because the 372, now here's the way it works. You have up to 5 pages where you can show a pattern of behavior of this particular federal judge. Like, is he always late? As a habitual practice, does he not follow the rules? It's not an appeal, gentlemen. In other words, you get all wrapped up in your own case and try to use this as a substitute for an appeal, it's not going to hold any water. But what we did was, we did this 372, and we sent it, every one of us, and literally, in fact, the funny part of this was a multi-level marketing organization, so they already knew how to do this. And 30 people volunteered. They, in turn, went to their downline, and this was in early April of 1997. Now, I didn't tell my friend what we were doing. I just figured, well, I don't know if this is going to work or not, so, you know, why tell him? And he called me. He got sentenced April 21st of 1997. He'd had this plan of how he was going to go in and literally raise every argument for bail pending appeal. Well, he walked into the courtroom. The first thing this judge said was, I'm sending all of you home on bail pending appeal. There were 14 defendants. My friend is looking at this judge like, you know, why is this? This guy doesn't act like this. And then my friend had raised a confrontation clause issue in this particular case. He had not been allowed to cross-examine some of the witnesses against him. And when he raised this issue in the trial, the judge just blew it off. But at sentencing, the judge got in this 20-minute argument with the prosecutor. The prosecutor wanted everybody locked up, and the judge said, oh, no, you know, there's some serious confrontation clause issues here. And this friend of mine, excuse me, is looking at this judge like, this is not the same judge. And he called me up. He says, Brown, he says, I don't understand this. He says, this judge spent more time discussing the confrontation clause in a 90-minute sentencing proceeding than he did in 10 weeks of trial. And then I told him what we'd done. And he said, oh, somebody held him